going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, got anything?
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Thursday. Hope you guys are all having a great day so far. All right. I've got a good one. Judge Elmore out of Michigan. This guy, I can't figure this defendant out. I really can't. He tries to tell the judge so badly that he never failed a drug. I don't know if I don't know. Whatever he was testing for, let's just say that. No idea what he's testing for, but I never failed one. Yeah, but you missed like 10, and then you showed up with someone else's urine for another one. Like, come on, man. He's like, but I never failed one. It's a good case. It's a little bit of a slow burn, a little bit of a longer one, but the end is good. And then we're going to finish with some Judge Van. Judge Van is back. I know I said it about, a week, 2 weeks ago that haven't seen him in a while. I was a little worried. He's back. And he will be back tomorrow. So, we'll be watching tomorrow as well. All right. Before I hit that play button, actually, giant shout out to Jen Hardy. Spent a little bit of time with her today. We went to lunch today. We hung out in a park close to me today. She is in the area, and we had a good time. So, Jen Hardy, giant shout out to you. That was a lot of fun. All right. Now let's watch some court. You want to watch some court? I want to watch some court. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Good morning, folks. We are on the record today for the 28th Circuit Court for Wexford County. And we are taking up the case of People of the State of Michigan versus Peter Lamont Brown. This is case number 24-13777-FH. Appearances, please begin with the prosecutor.
Joanna Carey, Chief Assistant Prosecuting Attorney for the People.
Your Honor, Dennis Duvall appearing on behalf of the defendant Peter Brown.
Mr. Duvall appears today via Zoom. Mr. Brown appears today via Zoom, but from the Wexford County Jail. Mr. Brown, are you able to see and hear the court, sir?
Yes.
Thank you. Also present in the court today is Miss Lindsay Simmon from the Michigan Department of Corrections, and also Miss Alex Matsky from the Wexford Missaukee Community Correction Program. We are initially here today to address a show cause, or actually to address an arraignment on a.
I have no idea what you're talking about. I do not love saying Heather's name. Oh, wait, hold on. I'm unmuted. I do love saying Heather's name. Hi, Heather. We just got off the phone. I'm just teasing her. What's up, Lone Wolf? I was talking to you. You're ignoring me again. Yeah, always ignoring you. Always ignoring you. Oh, Indestructible Cauliflower. Still one of my favorite names on the internet. That is an awesome name. Here's to keep you in a great mood. Just watch Tuesday and I feel for you. Take care. Yeah, Tuesday was a tough night, but you know what? Everyone came together. We're all good. We moved past it. Monday sucked. Let's just say that. You know what? It was Monday. I had a case of the Mondays on Monday, but we all have them every once in a while. But I appreciate it. Thank you so much. Thank you so much for the super chat. All right, let's keep going. Hi, Heather.
Bench warrant. A bench warrant was issued by this court a few days ago on July 15th. In that bench warrant, it alleged that the defendant failed to appear at a sentencing hearing and a motion hearing that was scheduled on that day, and also that the defendant tested positive, allegedly, for alcohol on 2 dates, which included July 12th and July 13th. Did he fail to appear for a test as well, Ms. Matsky? Is that what I see it's alleged?
We didn't have a weekend tester.
Okay.
He didn't come Monday.
All right, thank you. All right, make sure you speak up. You're right underneath the air conditioning. All right, so we're also here today. I think we can address a couple other things today, since we got Mr. Brown here and I've got all the right parties. we can address this motion to withdraw as counsel and as well as sentencing. So first, as to the bond violation allegation, the defendant does have the right to challenge those allegations at a contested hearing, which we can conduct today on the record. And if he's found in violation of his bond could be continued, modified, or revoked. Now, before I get to the next step, we are going to look here at the defense counsel's motion to withdraw as counsel. Mr. Duvall, you may be heard on that issue.
Your Honor, to be honest, Mr. Brown and I spoke shortly after I filed that motion, and my intention would be, if the court would deem this appropriate, for me to withdraw that motion and then have this case just proceed towards sentencing.
All right, the court hereby allows that withdrawal of that motion. That makes that point really easy. And the next thing we're going to do is turn towards sentencing. Mr. Brown, you have the right to be physically present in the courtroom for sentencing, or you can allow us to conduct the sentencing via Zoom. Which do you prefer?
What's the difference in the timeline if I'm there in person? Because I couldn't hear what she said when you asked her about I didn't show up for a test when on Monday.
Well, hold on. You've got multiple.
Okay.
You've asked me a question, 2 questions. So the last question was what Miss Matsky said. I asked her that to explain what the allegation was. There's an allegation that you tested positive, which I assume here is through the SoberLink device. Is that correct, Miss Matsky?
Correct.
Thank you. And also she said that you did not appear on Monday for a test. I'm not addressing that question right now, or that issue. That issue is off on the side. The only question that I have for you is, do you want us to bring you over here for sentencing, which probably would be on Monday, or we can conduct sentencing today, right now, via Zoom. Either way, it's probably not going to impact your sentence. So which do you want?
That's fine. We can do it now.
All right. Any objection to that, Mr. Duvall?
I have no objection to that, Your Honor, as long as my client is satisfied with that as well.
All right. Thank you. So now,
All right, you know what I'm not satisfied about? Can we get the court reporter a laptop or something instead of a typewriter? I don't know if I've ever noticed this typing being this loud in this court. Maybe this is the court where the typings are allowed. I feel like that was Judge DeSanto's court. No, that was Judge DeSanto had the chair. Whose court has the really bad typing? But all I can hear is typing. All right, anyways, I'm rambling. Let's go.
now we're going to take a look here at the pre-sentence investigation report, which appears to include a CFJ 145 and a CFJ 284B. Mr. Duvall, oh wait, hold on. Ms. Carey, do you have any amendments, corrections, or objections to make to that report?
Mr. Wiggins' notes.
All right.
No, Your Honor.
All right. Mr. Duvall, do you have any amendments, corrections, or objections to make regarding that report?
Your Honor, to the report itself, for the record, I would acknowledge timely receipt of this pre-sentence report. I have shared it with Mr. Brown for review. We spoke last Wednesday to review this report. The only issue that really came up was Mr. Brown's not in agreement with some of the statements regarding the testings that are noted. I believe it's on page 1 and continuing on to page 2 of CFJ 284. There was some documentation, I believe my office also forwarded to the court regarding some of that information. But I believe at this point that information is obviously part of the record and would also, to a certain extent be part of the narrative of this offense. So that was outside of that. That was the only issue itself with the factual material in the report. I would note that Mr. Brown and I did go over we discussed the family history, work history, stuff like that, and any of those things that we can address on the record.
Thank you. All right, the only thing the court is going to address are a couple of the obviouses. Number one, on CFJ 145, page 1, we'll need to amend the sentencing date to today's date of July 18th. We also need to change on CFJ 145, page 2, that the defendant turned himself in yesterday on July 17th. And he's there today, so we'll have an additional 1 day of credit, and of course he would get credit, but there's some question there.
I don't believe he turned himself in.
I thought he did. I thought Miss Genema, his bond's agent, talked to my office and told me that he was turning himself in. Mr. Duval, do you?
Wait, what? What? The stop sit in Washington. You got to be more specific. Judge Washington, or are we talking about in the state of Washington? Are we talking about SeaTac or what's the other one? There's a couple. Which court are you talking about? Is it the one that you sent me? Well, we have to have a conversation about this. Judge Washington had a soft sit today? Man. Well, I missed it.
You know, was it yesterday that he entered the jail regardless of how he got there?
That was my understanding, Your Honor, yes.
All right, so he doesn't receive credit for today because he'll get that credit when there's a sentence. So we just need to give him another days of credit. That gives a total of 26 days of credit, which must be corrected on both CFJ 145, page 1 and page 2. All right, let me take a quick look here to see if I had any other amendments, corrections, or objections to make myself. On CFJ 284B, on page 7, for entry 9 of 15, which I acknowledge resulted in a nollie pros. I see here that the defendant would have been on probation at the time.
Yes, Your Honor.
All right, so we'll go ahead and make that change. Then
Terry V, thank you so much for the 5 months. That's awesome. Thank you so much, bud. I appreciate it. That is awesome. 5 months. I still can't believe I had a channel for more than that. It doesn't feel that way. Yeah, no now has soft sits and the Texas Rangers coming after him. No, you just got to calm down in the chat, man. You got to calm down in the chats. Still can't wait for the Texas Rangers to show up. I really can't. And if you do record it, you got to record it. They knock on your door, hit the record on your phone and send me the file, please.
all right, thank you. I did not notice any other need for change. Mr. Duval, allocution, sir.
Your Honor, I've worked with Mr. Brown for quite some time now and really kind of gotten to know him. Mr. Brown is an extremely hard-working individual. Unfortunately, because of his last stint in the Wexford County Jail, he lost his employment. And to be honest, he is waiting for this matter to be resolved before he contacts employment and gets back to work. But I have no doubt that upon his release from jail, he will be able to secure employment almost immediately. In my conversations with him, he has always held employment. He has never had substantial difficulty getting employment. The difficulty he is going to have now is transportation. Because of the charge and the licensing issues that these charges bring for Mr. Brown. In addition, Mr. Brown is someone who is able to, give back to the community. I believe he was, while this case was pending, working and trying to do some community service to alleviate the cost of his reporting by doing some stuff down in the Lake County area. He does have a stable home. He does have the support of a significant other who's been to court with him several times, who I've spoken with. To be honest, Your Honor, we would be asking this court to consider imposing a sentence of the 26 days in jail, give him credit for time served, and the financial assessments that are indicated. I don't know if this court necessarily imposes an attorney fee by matter of course or not. I think maybe initially Mr. Brown was appointed to the defender office, and then retained a couple of different attorneys before retaining myself. So we'd ask the court to exercise its discretion in the imposition of the financial assessments. But we would ask this court to consider the time served, fines, and costs in order to allow Mr. Brown to get out of jail, have this matter behind him, and be able to maintain employment. As the court is fully aware, and looking through the pre-sentence report, Mr. Brown really has not been in any trouble in the better part of almost 12 years now. So he is somebody who can certainly stay out of trouble. I think his younger days reflect that he was a younger man. Now he's grown up and matured up and has taken every effort he possibly can to stay out of trouble. And that is reflected in the pre-sentence report with that gap between number 13 from 2011 and then a matter that was dismissed in Lake County in 2022 and then this matter. So we'd ask the court to take those factors into consideration when imposing an appropriate sentence for Mr. Brown.
Thank you. Ms. Maskey, have you had any report from Mr. Brown about performing community service to help pay for any of the costs for programming through your office?
There was conversation about it a while ago, but never followed through.
All right,
that we were aware.
Thank you, ma'am. Ms. Carey, on behalf of the people, ma'am.
Thank you, Your Honor. On behalf of the people are going to request.
Before the prosecutor speaks, Mimi, good to see you. Also, Cincinnati Bengals reference. I want to hear a Cincinnati Bengals reference, but you got to learn how to spell Cincinnati first. I don't know what that is. I guess yeah, Cincinnati. Yeah, just an extra T. It wasn't actually that terrible. I've seen people that live there that can't spell it, so yeah, not terrible.
That the court follow the recommendation of the probation department. Mr. Brown has a very poor performance on bond. And what that tells people is that he's going to not follow the rules of probation either. His bonds person went and got him yesterday. That's how he turned himself in. So I'm not sure how voluntary that was. Mr. Duvall said that he lost his employment because of his last stint in the jail. His last stint in the jail was because of his actions, not because he was in jail, but because of his own actions. We have serious concerns about his supervisability. I don't think that 26 days, frankly, is enough for this behavior, and would ask the court again to follow the recommendation.
Thank you. Mr. Brown, you have the right to make a statement before the court issues the sentence. Is there anything you wish to say today, sir?
Yes, Your Honor.
All right.
As far as oops, go ahead.
No, it's all right, sir. You may speak. Thank you.
All right. As far as
All right. I was talking to the chat for the first part of this video. This is when this video gets good. This guy's gonna tell his absolute truth to the judge, right? Absolute truth. Just wait till Judge Elmore responds to him. It's kind of funny.
behavior she talking about, I served my time for that one violation, which I explained at that time that was about my teeth. I went and my attorney has the paperwork. I sent everything to him, and that's why I didn't come to jail. You know, didn't nobody force me down here to bond lady or anything. I called the bond lady on my own because I called the courthouse twice on Tuesday morning trying to see what I need to do to get down here. I was there. I had a dentist appointment. I finally got the tooth taken out of my mouth on Monday at 10 o'clock in the morning. It was my fault, my mistake, because I was thinking court was at 1:30. And I got my 2 full day 10, left the dentist at 11:08. And me and my girlfriend ran around to the lake and sit there waiting to go to court at 1:30. I arrived at the courthouse at 1:45, sit out in the parking lot to 10 minutes after 1, got up and came inside and went in the courtroom and it was empty. I looked on the board at the dockets and I seen my name and it said 11:30. I instantly called the attorney. I called his office. She told me to go in and talk to the clerk. I came in there and spoke to your clerk and everything. And like I say, as far as missing alcohol tests and everything in that report, it's not true. I blew dirty Friday night because, like I said, with my teeth, my teeth been killing me for like 5 months. I got up the next morning on Saturday morning at 6:30 and called in like I usually do. It was the same recording on there and test numbers from Friday. I went to the community corrections when I go report, and I kept asking on more than one occasion for the test numbers on April 7th when I got violated for the alcohol last time. They couldn't come up with them. They don't exist. But when I called Saturday at 6:30, it was the same recording from Friday, the same test number. So that tells me it's not no testing today. So I called back until 7:40. And then I get a text at 6:58 saying, no, 6:48, saying it was a message from the sober lane thing saying that you need to report for or test from the hours of 6:30 to 7:30. I couldn't even get there by 7:30 in the morning. And as far as Sunday goes, I called in on Sunday. There wasn't no testing on Sunday. And I called in on Monday and my number did not come up. So I haven't missed any days. You know, I done lost everything behind this, Your Honor. You know, and it's been 8 months. I think as far as probation wise, I done pretty much did that already. That first, and I also sent paperwork to my attorney. When I was told by the other judge when I first started this case, when I was over the road being able to drive and go work, that the community corrections would provide a place for me to go drop when I'm on the road. I just call them and let them know where I'm at. I'm thinking they would call the courthouses, and I would just have to go somewhere like that and drop. I had to do all this on my own. So the first time I did that in January 7th, when I got that dirty job, a place called Accredited Drug Testing, I found them on my own on a Sunday and did all this. They ended up sending results back on like that Thursday. And I looked and did my research on it. They got 2 stars. And the reviews, everybody talking about how they a scam and this and this and this and this. As far as Wexford County goes, I do not have no positive ETGs or.
I didn't realize I thought I was muted that entire time. You guys probably heard me laughing and chuckling to myself. Yeah. First and foremost, Biggin, thank you so much for the raid. Welcome to all the raiders. Thank you so much for hanging out with us. You guys kind of came in at the perfect time because the first half of this case was kind of boring. They're reading off all of his bond mess ups. What I can't think of the word. Words are hard. But you guys came at the perfect time where he's just ranting. But no, the testing place has 2 stars. The testing place has 2 stars on Yelp. Why would I go test at a place that has 2 stars on Yelp? Not going to do it. No, you got to have 5 stars. If you don't have 5 stars, I am not testing at your location. That's not what he said, but I'm just going to say it anyways. Anyways, Biggin, thank you so much. And KCC's incoming too. Did we just get a KCC and a Biggin raid at the same time? KCC, thank you so much for the raid. Thank you so much. Again, you came in at the perfect time too. I feel like I need to rewind the video about 2 minutes though, but no, I'm not going to. All right, let's see. Oh, I gotta make sure to call out a new member. Oh no, Rena. It's Rena. That's how you say that name. I don't know why, but I saw the letters and I thought Reno D, but nope, it's Rena. Okay, thank you so much for becoming a new member. I appreciate it. Thank you. You are awesome. Welcome to the family. All right. Yeah, there's KCC. Yeah, don't do that. Don't double team me. I'll lose twice. That's not fair to me. It's not fair to me. All right, you guys are awesome. Let's continue with this guy's rank.
Drug tests in Wexford County in the last 8 months. And I also, my semi-truck and my trailer is at the truck stop on M55 and M37 at the truck stop. I have to go down there every week and move it around so they don't tow my truck because I don't have room at home to store my truck. I done got my stuff repoed. My credit done went from 700 to 400. I ain't been able to work because of the blow situation. I just want my life back, man. And I want to lose the last thing I got to try to help me get back on my feet.
How did you get here? How did you get to this position?
He already said it, Judge. He wouldn't go test at a 2-star location. They didn't even have 4.5 stars. They had 2 stars. That means the people that went there to test were not satisfied with their experience at the testing place. They only had 2 stars, Judge.
The night when I got pulled over.
Okay.
It was my fault. I accept my responsibility.
All right. Good. So how about the day that you showed up at the community corrections office with the fake urine on you? What happened there?
What do you mean?
That's where this is where this case gets really good. Oh yeah, you wouldn't go test. All right. What about the time you showed up with the fake urine? Wait, what? You guys know about that? Oh no. All right, I'm gonna let this play a little bit. I paused it way too much in the past couple minutes. You guys are awesome. Again, KCC, Big, and thank you so much for the raid. All right, let's keep going.
You know what I mean. You had a bottle, you had a container of urine with a temperature strip as you tried to falsify a urine drop. How did that happen?
Well, I don't know what you're talking about.
You don't know what I'm talking about?
No.
All right. Well, see, here at a sentencing hearing, the rules of evidence pursuant to Michigan Rule of Evidence 1101 says that the rules don't necessarily apply, which means I can take a look here at the evidence that's contained in the file, and it appears that you had attempted to falsify a test by having a bottle, or I don't know if it was a bottle or a container of urine with a temperature strip. What about that? Was that their
test that day? I didn't test that day.
Just because you had a.
So how did I attempt?
Okay, hold on. That's all right. I appreciate there's some tension here. We're gonna make sure we keep the court calm. The point is you came in that day with fake urine to try to falsify a test. How was that anyone else's fault? How was that anyone else's fault but yours, sir?
I didn't test that day, sir.
I know you didn't test. That's not my question, and you're choosing not to answer the question. The question that I'm going to ask only one more time, and depends how you answer it. It's all up to you. Why did you come to the community corrections office here in Wexford County with a bottle of urine and a temperature strip on that day? Why did you do that?
I don't recall doing that.
You really don't? Okay. Well, I can take in consideration here the evidence contained here in the file, but also in the pre-sentence investigation report that you did it. And maybe you don't remember. Maybe you were intoxicated. I don't know. Maybe that's why you came with the urine. I don't know. But the clear here answer is yes, you did. Now, let's take a look here. I noticed inside your handwritten statement, and I think you may have answered this, so forgive me if I ask the question again. It says here at the end, this whole situation has turned my world upside down. I have lost everything, including my ability to maintain my career. All right. Whose fault was that?
Mine, sir.
Good. All right. Thank you. And that's the key issue here. When you talk about pointing to community corrections and you talk about issues there, maybe it was this past weekend. I don't know. My focus here is ensuring that you understand why you are here. And it is not the fault of community corrections. It's not the fault of anyone else. It is strictly your fault, no one else's. Now, there was another thing here inside your statement that you said that later, it says, quote, later I found out the joints had cocaine in them, end quote. Is that true? You didn't know there was cocaine?
Yes, sir.
Yes, you did know, or no, you did not?
I did.
What I meant to say was yes, sir, but what it came out was yeah, sure. Officer, I don't. Yes, sir. Yes, sure. I don't know. I don't. Oh man, this guy. This guy's a winner, right? All right. I had to pause it. I gotta catch up. Hey, Colin, boo Reds and Bengals. Bangles. Yeah, Ed, you can boo us all you want. I mean, the Reds are getting better though. They're getting better. So watch out. And the Bengals, yeah, I already put a bet on the Super Bowl. Just saying. Let's see if you say that come January for the Bengals. The Reds aren't going to do anything this year. They're not going to make the playoffs. But the Bengals, watch out. Last year with T. Higgins, we're going to blow up. Roland G. Good to see you. Keep it up, Colin. I see you. Thank you so much, Roland G. I appreciate you. Thank you so much for the 1 month. All right. Let's keep going. I don't know. Can we top this? I don't think we can top this.
Did not know at the time.
Okay. All right. Well, there just happened to be cocaine in the car.
Somebody was rolling in my car.
All right. So, interesting. All right. Thank you. So, not really sure how to take that, but I can note there that there was cocaine in the vehicle. Now, hold on one moment. Now that does kind of raise a bit of a question. 1 second here as I take a look at something in the file. When the court accepted the plea, and I know Miss Carey wasn't here because now I remember that was Mr. Wiggins' case, or this has been Mr. Wiggins' case, who could not be here this morning. Carey, could you tell me what the blood draws? I think we did there was a stipulation as to what the forensic lab had said. It was in the defendant's system.
So I have. Just want to make sure they're blood.
There's one blood, and then there's another one where they tested an amount of cocaine that was not in anything, but was just in the car.
Ones I'm showing that were blood. Benzo, like gonine.
Okay, what else?
That is cocaine.
All right, real quick. The attorney tried to withdraw at the beginning of this case. For everyone that came in late, the first motion on the calendar was the attorney trying to withdraw. And the attorney said, yeah, I filed a motion to withdraw, but after speaking to him, he's going to accept the plea deal, so I will stay on the case. Yeah, he was already checked out of this. So he should be fighting. He should be saying something, I guess. I don't know. This just seems, I don't know. This turned into a circus real quick. Anyways, Bill Rhodes, thank you so much for the 5 months. Hit that like button. Yes. Don't be a duty head. Don't do it. Bill Rhodes is going to call you a duty head. Bill Rhodes, good to see you, man. Good to see you, bud. I appreciate the 5 months. That's awesome. I'm running out of breath from laughing too hard at this. All right, let's keep going.
Was detected in the blood in one sample, and then THC.
Okay. All right. All right. So anyways, all right, thank you very much. Well, Mr. Brown, now you mentioned something.
Your Honor, if I may, I'm sorry. There was also a .122 alcohol.
Yeah, all right, thank you. I remember that the charge said, and I went back and reviewed it, that it involved alcohol and controlled substances. I just wanted to make sure I understood that. Mr. Brown, you said something about you think you have already done probation. Is that correct?
I said it's like pretty much like probation because I've been doing this for 8 months and I don't have any positives.
All right. The reason that I asked that question is because a defendant does have the right to request jail in lieu of probation. In other words, and it always seems odd to people that the court can't give you probation if you say, nope, I don't want it. I'd rather have jail in lieu of. Is that what you're asking the court?
You know what, Tumble Dry Low? That is the perfect excuse to bow out. I hope you have a great evening. I hope you beat all the bosses without using any of your health potions. And yeah, get to the save point right after the boss. So, total victory. Have a great night, Tumble Dry Low.
I'm asking the court that, you know what I mean? I don't want to do probation because like I say, I've been driving over here. I don't even live in New Wexford. I've been driving over here doing this for 8 months.
All right, that's all. Yep, I just wanted to make sure. Again, it's your right to make that statement. I just had to make sure that I was interpreting your comment correctly. And so the answer is that,
I wasn't appropriately asking for jail time. I don't want to do jail time, but I just didn't want to do the probation.
All right. Well, all right. So the court understands that the defendant is requesting the sentence does not include probation. All right. So this court first must find before any jail can be given. In fact, because it's a misdemeanor, before even probation can be given pursuant to the law, whether or not there are, quote, reasonable grounds for a sentence involving either probation and or jail. So one moment here as I take another look here at the report.
Vince, the jail No, don't interrupt me. I'm the one talking now. You're interrupting me. I'm the one who interrupts court, not you, defendant. Vince, he doesn't want the jail time because the jail only has 2 stars too. He doesn't do anything below 4.5 stars. All right. All right, let's keep going.
Use the bathroom real quick. I've been in the holding tank laying down all night. I gotta use the bathroom really bad. It take me 2 minutes.
Sure. Go right ahead.
All right.
We'll go ahead and recess here in place. Thank you. Never had that request made.
Oh no. I gotta fast forward. I don't remember that part. Don't remember that part at all. Hey, perfect timing. Look at that.
All right, thank you.
I'm an
we
awesome
are back on the record for People versus Brown. All parties present when the court recessed are again present, and Mr. Brown is also here via Zoom. All right, so again, the court was taking a couple minutes during that brief recess to review again the pre-sentence investigation report. The court here notes the following things contained therein. Number one, this case began when the defendant had allegedly a non-functioning registration plate light, not the biggest deal, but there's a minor violation there. And then he appeared to be speeding as the officer pursued him. But the traffic stop was initiated and Mr. Brown did stop and provide his information. Mr. Brown did make false statements to the law enforcement officer saying that no, he hadn't been drinking and so forth. And then when he was asked to take a blood test, he had said no there, but he did provide, looks like some preliminary breath tests. The court also notes that there was cocaine found in the defendant's vehicle. That charge was dismissed. The defendant had received a significant benefit from that, and the court can consider those other offenses for which I find that there was evidence to support based upon the evidence contained here in the file, contained in this pre-sentence investigation report, and also that resulted during a motion to suppress that we dealt with here on the record. The court also takes notice that the defendant's performance on bond, and I do appreciate and understand the difficulty that the defendant had, considering he is from another county, but his performance on bond has been quite poor. And most particularly, despite his denials today here on the record saying, well, he actually didn't deny it. He just said he didn't remember. Well, there's complete evidence here in the file that the defendant, who has tested positive with alcohol repetitive several times and failed to provide samples, at least some of these instances, but even most importantly, the defendant tried to pull one over on the eyes of those in community corrections by coming one day with a bottle of urine. Now, he didn't test that day because, of course, why were they going to test a defendant who was there to try to pull over one on them and had a temperature strip and a bottle of urine or a container of urine? That's just unacceptable. I do understand that he had some issues maybe this week with the tooth and having it pulled. All I know is that there were some positive tests apparently back in June and also here possibly in recently in July. Now, the court also takes a look here at this case and looks at this defendant's prior criminal history. And he has had multiple cases involving controlled substances. That's concerning to the court, especially when I think one of them dealt with the same substance that for which he tested positive, which was cocaine. He had a couple dismissals, but he also had a couple arrests while on bond and even convictions while on bond. Looks like he had an operator while intoxicated back in 2007. He was on, and that offense occurred while he was on bond. I'm not surprised that we have a bond violations in this case. And then in 2007, again, in another case that is entry 6 of 15, while there was a not guilty plea or not guilty fine of trial that did there was an arrest on bond, but I can't hold that against him and do not because there was a not guilty finding by a jury trial. However, we then look on in 2008 for entries 8 of 15. The defendant violated violated probation.
When?
2008. So then we're going to continue here. The court sees that the defendant has a problem complying with bond and probation. His conduct here in this case has been completely unacceptable. Some of the reasons why the court allowed the defendant to return on bond was simply to give him a chance to perform better, and that apparently failed. The court therefore finds reasonable grounds in this misdemeanor case for a sentence. The court also notes that the defendant has requested not to be placed on probation. Therefore, the court issues the following sentence. The court issues a $50 state minimum fee, a $75 crime victims' right fund fee, a $300 fine, $150 court cost, a $150 attorney fee. The court sentences the defendant to 93 days of jail and gives the defendant 26 days of credit. Have I missed anything, Ms. Sim?
No, Your Honor.
Ms. Carey?
Thank you, Your Honor. The people would request a $100 prosecution fee.
Oh, and there's a $100 prosecution fee, which is permissible under the law for drinking and driving offenses. Thank you, ma'am. Mr. Duvall, do you have any questions or anything else that you think I missed regarding the sentence today, sir?
You have not missed anything, Your Honor, no.
All right, thank you very much. You know, there's one thing that I should have also noted here in the pre-sentence investigation report, which I'll merely add, when I looked at CFJ 145, page 1, underneath the defendant's personal history regarding substances, cocaine's on there. I'm not surprised, again, the defendant who has been using cocaine and marijuana for several years. And I'll also note that there's no end date for that. And therefore, the court applies that again for its reasonable grounds. All right. Mr. Brown, you have the right to appeal a conviction and sentence in your case. That is done by filing an application for leave to appeal and not a claim of right to appeal. If you wish to have the court appoint an attorney to assist you on an appeal, you may complete a form that will be provided to you at the jail and return to the court within 42 days. Thank you. Anything else? Yes, sir. I got
a question.
Yes, sir.
I explained the situation about my semi truck and my trailer being at the truck stop. Is it any way I can get a week to try to get my truck removed and then I turn myself back in like I did yesterday?
Well, again, as I mentioned earlier, some of the reasons why the court allows you sometimes to continue back on bond was to demonstrate some graciousness here. Plus, again, I wondered what you would do while on bond. The court has done extending those opportunities. How you get that taken care of is on you.
Yeah, that was weird. I don't know if I've just mindlessly passed over when the judge is giving out the fees, a prosecutor fee of $100. I don't know if I've ever heard that before. You're paying the prosecutor to charge you with crimes? Isn't that what taxes are for? I mean, I'm just saying. I don't know. Again, I don't know if that's just the first time I've heard that or I just bypass it because when they start reading numbers off, I really just don't care. I think they should just list out a receipt. I think it's dumb they have to put it on the record. Can you imagine if you go to a restaurant and before they give you the bill, they read out the entire ledger to you? I get it, but it just, yeah, I mean, there should just be a touchpad in front of them. Do you accept the charges? Yes. Do you want to tip 10%, 15%, 20%? That's what he should have, like every normal human. Vicky, thank you so much for the gifted membership. I appreciate it. And whoever got the membership, welcome to the family. All right, let's finish this one up. It's almost over.
Thank you.
How is that, Your Honor? And I don't even have no no positive test or anything. So what have I done on mine? What do you need? Since I've been out May 10th, I don't have any positive test or anything. I done took 3 ETGs, and they all was negative.
All right. Well, again, I've already explained my sentence, and I have looked at the evidence contained in the file regarding the bond violations. And particularly, I've highlighted the one where you came in with fake urine. I cannot tell you enough. That right there says a great deal about your ability to comply with conditions of bond and or probation.
You said earlier too that I didn't drop because I had to. That's why they didn't drop me. They didn't drop me because she called me down there to arrest me for the warrant. But it's all good. It's all good.
I'm sorry,
I'm just trying not to lose my last piece of material that I had. There were 20 ways I can't afford to get it out.
All right. Well, just taking a moment to calm down. See, this is the new and improved Judge Elmore. So, Mr. Brown, I do appreciate that you don't like some of this result. This court, respectfully, it's not concerned with whether or not you like it or whether or not it is easy. I've highlighted very thoroughly today all the reasons for reasonable grounds, as well as, I should say, proportionality and reasonableness in the sentence. I'm not going to explain it any further, and I'm really caution you, and I'm sure Mr. Duvall would probably agree, you probably don't want to say anything more at this time. Thank you.
It cut off right there. The string cut off right there, so there was nothing else there. Yeah, that guy's a train wreck, or should I say a semi wreck, because he's apparently a semi truck driver. All right, you guys ready to watch some Judge Van? Let's watch some Judge Van. We haven't seen him it's been over a month, and as I said in my intro, I haven't seen Judge Van in a while. And when it popped up that he was on, I tried to grab as much of his content as I could. I only got about 20 minutes of it, and we're gonna watch all 20 minutes that I grabbed because it's Judge Van and it's Thursday. Let's have some fun with Judge Van. Yeah, last guy probably gave Judge Elmore maybe 1 star. He gave him 1 star. He gave him 1. I don't think he gave him 0. He gave him 1 because he listened to him. He got 1. All right, Judge Van, let's go.
Ambro is resting. Miss Ambro, are you okay?
No, of course not.
Well, pray tell, what's wrong? And how can I help?
Because I had to come to work.
Oh, I'm sorry. I can't help with that. We stuck.
Kind of am.
Before we get too much into this, yeah, Judge Van changed his setup. Changed everything about this. Look how small he is at the bottom. We don't even get to really see his expressions. He's tiny. Judge Van, you got to go back to your normal, where you're on the side and we can see you, drinking your coffee. Even when you had your arm brace, we all cared about your injury and wanted you to recover quickly. Now we don't know. You could still have your arm brace. I don't know. When are you going to drink your coffee? I don't know. When are you going to face palm? We don't know. Judge Van, go back to your normal setup, please.
Have me go to the armory. Solemnly swear to truthfully and accurately interpret the contract support in the defendant day.
I do.
All right. Ms. Ambro, are we waiting on you?
You're waiting on Steve. Call him by his right name.
You're the face of the franchise. You're the show.
They don't pay me to be the show.
Yeah, but you are the show. Everybody loves Ambro. And Judge Van, he's a jerk.
Yeah. He said he waiting on you. He called you by your name.
He's not ready?
He was waiting on you. He called you by your name.
By my name?
Yeah.
She ain't ready for me. You don't want it.
All right. You want to ask her to say her full name for me?
Dígale su nombre completo al juez.
Ms. Barrios Alvarez is for the court charged domestic violence assault with a deadly weapon. Does she understand that charge?
Señora Barrios Álvarez está frente al juez acusada de asalto doméstico con un arma mortal. ¿Entiende el cargo?
Sí, lo entiendo.
Yes, I understand.
I understand she's been given copies of paperwork and advised of her rights.
Entiendo que se le dio copia del papeleo y se le notificaron sus derechos.
Based on her application, she does qualify for the services of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender representative.
Según su solicitud, determino que califica y le asigno la oficina del abogado de oficio para que la represente.
Deputy, criminal history.
Try to inadmissibility out of Texas in 22 with no further tracking.
Bond set at 10,000. No contact directly, indirectly, or through a third party alleged victim. Court date's going to be August the 5th at 9.
Your Honor, can you repeat the bond amount, please?
10,000.
La fianza van a ser 10,000. No puede tener absolutamente ningún contacto, ni directa, ni indirectamente, ni por medio de una tercera persona con la supuesta víctima. Próxima audiencia va a ser el 5 de agosto a las 9 a.m.
Perdón, no entendí bien qué.
I'm sorry, I didn't understand. What did you say?
You can repeat it if you need to, Jordan.
Su fianza son $10,000. No puede tener ningún contacto, ni directa, ni indirectamente, ni por medio de una tercera persona con la supuesta víctima. Su próxima audiencia es el 5 de agosto a las 9 a.m.
Okay.
Go in this
Over
right
there. Step over there.
Pase por allá.
Signature pad got disconnected.
All right, I know I don't generally keep in interpreter cases, but it's Judge Van. I'm gonna keep it in. And like I said, I grabbed as much of this docket as I can. He deletes quickly. So like I said, I got how many times can I say like I said? We got about 20 minutes of this. So it's Judge Van. We all love Judge Van. Joey, thank you so much for the 5 gifted memberships. Thank you so much. That's awesome. And thank you so much to that's not what I was going to say. Welcome to the 5 new members. That's what I was going to say. Thank you, Joey. I appreciate it. And welcome to the 5 new members. All right. Judge Van, let's go.
Is it unplugged?
Oh, she went mute.
What was that, sir?
The signature pad has been unplugged or something. It's offline.
Look over and see if the lights are on down there on the white cord. Give me 1 second.
It always scares me when she silences it. I hear you. I know you hear me.
Your Honor, may I be excused?
Thank you, Jordani. Yes.
Thank you, Your Honor.
I anticipate seeing you tomorrow, sir.
Yes, sir. See you then.
I see Mike. I see Alexa. Can't tell.
We're up. You can reset. State your name, sir. No, it's finished. Now just reset.
Joshua Nolan.
Mr. Nolan, you're before the court on a faith fine for a petty theft charge in front of Judge Grammer. You understand that, sir?
Yes, sir, I do.
You've been sentenced per caput for 15 days in the Bay County Jail, but you may purge out upon payment of $572.
Yes, sir. Thank you, Your Honor.
Terry, are you resetting or are you sending 2 copies?
I'm trying to reset that.
We are attempting to
Yes, sir.
reset.
Sir, step out to the left and stay on that side real quick.
I would not hold my breath.
Next. Red X, sir.
We rolling. How you doing, Mr. Stallings?
Yeah,
Sir, you're before the court charged with possession of methamphetamine, possession of paraphernalia. Do you understand those charges?
I don't know where that came from, but yeah, I guess. But when I was told when I was arrested, I don't know where this is coming from.
Okay, well, sometimes it just falls out of the sky. Sometimes it pops up out of the ground. Sometimes it just grows as if a fungus in your pocket. I don't know. But anyway, I just need to make sure you understand what the charge is.
Yeah, I got you.
I understand you've been given copies of paperwork and advised of your rights. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
All right, so sometimes the charges fall out of the sky. Sometimes they grow in your pocket like a fungus. We need to clip that. Also, that like button needs to grow out of your pocket like a fungus. Please hit that like button. I need to say that more often. I don't, but I should say it more often. So Judge Van just said that like button in your pocket. Press it. Let's go.
Jeff, you come on this year, Mr. Stallings?
23, controlled substance, petty theft second. 19, grand theft. Grand theft auto, criminal mischief, burglary, unarmed, petty theft. A parole violation. 17, FTA, opium with intent, petty theft, para, goes back to 13.
Bond 7,500 on the meth, 1,000 on the paraphernalia, random UAs, court dates August 15th at 9 o'clock. Good luck, Mr. Stallings.
Step out to your left. What was that, Terry? It's working. Step over.
Yeah.
Nolan, come into the signature pad. Next.
Thank you.
Thrift. Step on the red X. State your name.
Mr. Thrift, before the court charges 10 counts of possession of obscene child material. Do you understand that charge? Yes, no, maybe?
Yes, sir. Sorry.
All right, Mr. Thrift. I understand copies of paperwork and advise of your rights. Mr. Rollins, do you represent Mr. Thrift? What would you like to tell me, sir? What was it?
Approximately 10 years as stepfather. He does have no priors. I wasn't able to look at this morning to see how serious other than the nature of the charges, but that just has to just read on to make sure.
All right, bond is 2,500 per count. So it's a composite 25,000. Let's just do a composite. I think it's easier for everyone. All right. So composite 25,000. And no internet access. All right, Mr. Swift, your court date's going to be August the 29th at 9 o'clock. Good luck, sir.
Step to your right to the T. When the green light comes on, sign. Next. Uber, step on the X. On the X. Here you go. Face the TV and state your name.
Samantha Llewellyn Hoover.
Ms. Hoover, you for the court charge of domestic violence battery. Do you understand that charge, ma'am?
You understand what you're charged with?
Yes, sir. I'm sorry.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
All right. Based on your application, finding that you do qualify for the services of the public defender's office, I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
No, sir.
Deputy criminal history, Ms. Hoover?
Florida, Mississippi, Indiana, South Carolina, Kentucky. Domestics in each with 15 FTAs. The latest one was in 23.
Huh? She should be in desk.
15 FTAs. 15 failures to appear. Yeah, I don't think she's going to come back to court, Your Honor. Judge Brand, she's not coming back. 15 FTAs. No, one or two can possibly be like, oh, you know, I changed my address, so I missed that one. All right. Well, it's an order of your bond or probation that you got to update your, address with the court. But okay, whatever. It's your first one. We'll let that go. Second one. Oh, I was working. I came in late, and okay, you know what? We're gonna violate you. We're gonna charge you. You're gonna have to do 8 hours of community service because of this. 15. Yeah, you're not going anywhere, lady. You're not going anywhere.
In the Southeastern Conference media days. All right. Ms. Hoover, I just don't know that you're going to show up in court.
Excuse me, sir. I reside here in Panama City now. I moved here almost 3 weeks ago.
Oh, that's like put down roots.
Excuse me, I'm sorry, sir. Well, I travel on the road with my boyfriend and his job.
Yes, yeah. It seems like a bumpy road.
Judge Van, I moved here 15 weeks ago. Oh, so you're putting down roots. I travel with my boyfriend. Yeah, that sounds like a bumpy road. Judge Van. You gotta love it. All right, I have David. Thank you so much for being a member for a month. That is awesome, David. I appreciate it. Thank you so much for the membership milestone. All right, who we're gonna raid tonight? We got about 10 minutes left of this clip. There are a couple options out there. Who we're gonna raid tonight? We got 230 people here. Where do you guys want to go? Where do you guys want to go after this? The name that I see most in the chat will raid. All right, let's keep going.
I have no reason to believe that you're going to appear in court, so I'm going to hold you without bond. Your court date's going to be July the 19th at 8:30. No contact, directly, indirectly, or through a third party alleged victim. Good luck, ma'am.
When is my court date?
In the morning. He's holding you overnight.
Okay, thank you, sir.
Step on the T. On the T. When the green light comes on, sign. Next. Red X, state your name.
Attorney K.
This case, legal on failure to appear for 3 felony charges or 3 charges that were attached to 2 felonies in front of Judge Stevenson. You understand that, ma'am?
Yes, sir.
Judge Stevenson and his infinite wisdom is where you held without bond. Your court date's going to be August the 26th at 9 o'clock.
Yes, sir. Thank you.
Next. Lauriston. Red X, state your name.
Ms. Lauriston, for the court on signal duty card. You understand that, ma'am?
You understand what you're here for?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Got a copy of your paperwork? Were you advised of your rights today?
Yes, sir.
All right, ma'am. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
He gave you a public defender.
Yes, sir. Thank you.
Deputy, criminal history?
No history.
One of the most heinous fleeing and eluding I've ever seen. We got 35 miles an hour. I don't know that really. All right. Pretrial release her. You need to be at the pretrial release office before 9 o'clock Monday. You can go tomorrow if you need to. Court date's going to be August the 29th at 9 o'clock. Good luck, ma'am.
He's letting you out. Step on the T. Yes, ma'am. When the green light comes on, sign. Next. It'll come on in a minute.
Okay.
Red X, ma'am. State your name.
Higgins.
Ms. Kiggins, you're before the court on a failure to pay fine for a no valid driver's license. You understand that, ma'am?
Yes.
You've been sentenced per capus, served 10 days in the Bay County Jail, but you may purge out upon payment of $450.
All right, thank you.
All right. Just step on the T.
Did we have a warrant so we for something?
Next.
Yes.
When the green light comes on, sign. Red X, state your name.
Yes.
Mine.
Ms. Munn, you're before the court on a failure to pay fine for a petty theft charge. You understand that, ma'am?
Yes, sir.
It's been sentenced per capus to serve 60 days in the Bay County Jail, but you may purge out upon payment of $450. Good luck, ma'am.
All right, step behind her. Next. Sign. Sign. Higgins, sign. Next. Red X, ma'am. State your name.
Swin, you're before the court charged of domestic violence battery. Do you understand that charge, ma'am?
You understand your charge?
I understand you've been given copies of paperwork and advised of your rights. Is that true?
You got a copy of your paperwork? Were you advised of your rights today? Were you advised of your rights today?
It's a mix and match. They gave her a new top and old pants. Look at that. Faded pants. Oh my gosh. You don't even realize how new the new tops look until you see them with the faded pants.
Well, that's not a new top.
Well, that's newer.
I mean, Judge Brand's got a point. That looks crazy. One looks black, one looks kind of green-ish. Just saying. That yeah, I'm not a fashion expert though, but that doesn't match. It doesn't. She's trying. She's trying not to laugh too. Also, Miss Fambro, she's like, Judge, come on, can we just get through the docket? Every time you're here, Judge, the docket takes an hour longer because you got to get your quips in. But we love your quips, Judge Van. We do. And we love you, Judge Fambro. Not Judge Fambro. Wow. Miss Fambro.
Yeah.
Officer Fambro. Officer Fambro.
Based on your application, ma'am, I find that you do qualify for the service of the public defender's office. I'm going to appoint the public defender to represent you. Any question about that? You got a public defender now. All right, ma'am. Y'all from Oklahoma?
Yes.
What brings you down to this?
We came down here to celebrate my grandma's memorial.
And you and your sister got into a disagreement?
Yes. It was little girl drama.
When are y'all supposed to go back to Oklahoma?
I think Monday, I do believe.
Okay, good. All right, your court date's gonna be tomorrow morning.
Okay.
Now, here's the deal. I've got to order no contact between you and your sister, okay?
Okay.
But she can come to the courtroom with on her own as the victim in this case and talk to the prosecutor.
Okay.
Our date is going to be tomorrow morning, July 19th at 8:30. I would imagine we can get this whole.
J Hart, that was when I used to visit Outer Banks, North Carolina. That was the logo, like the click it or ticket signs I see everywhere in Ohio. That's what they had in OBX in Outer Banks. There were signs that say "Come on vacation, stay for incarceration" is what it was. So it wasn't the exact same thing, but that's what they said. Like, don't drink and drive. You come on vacation, you stay for incarceration. Like, really? That's what you're promoting? I mean, hopefully it worked. I mean, the bad part is you're a vacation town, so pretty sure everyone you pull over has probably had a drink. Hopefully just one. Hopefully none. But yeah. Anyways, let's finish this up. We have a raid coming. Also, I was told to pause for Jay. Jay, if you're here, you told me that I got a message on Discord saying, here's some information. You'll like it. And I appreciate the information. And what they asked for in return is an extra pause for Jay tonight. So this is the extra pause for Jay. Hopefully Jay is somewhere in the Ethernet and will hear this. But we got about 4 minutes left. I'll pause to say goodnight. And we have a raid scheduled, so it's going to happen. So yeah, I'm going to let this play for about 3 more minutes, and I'm going to say goodnight.
Thing resolved. So you don't have to go back to release her on her own recognizance.
Yes, sir. Step to your right to the T. When the green light comes on, sign right there. Next.
Can't fight.
Red X.
Oh man. Nobody got hurt.
That's yours.
Nobody got hurt. Miss Bruton, how you doing, ma'am?
I've been better, thank you.
All right, well, I understand that. Miss Bruton, you're fully court charged driving under the influence. You understand that charge?
Yes, I said, yes, that's what I have for the charge.
I understand you've been given copies of paperwork and advised of your rights. Is that true, ma'am?
Yes.
All right. Based on your application, you make too much money to qualify for offender, but the law recognizes your financial situation may change, in which case you can reapply later. Any questions about that?
I don't know.
Make too much money for the public defender, but if that
Okay,
changes, you can change.
I understand, yes, I understand.
You can always hire your own attorney or represent yourself. Deputy criminal history, Ms. Bruton?
No history.
No, sir.
I'm going to release you on your own recognizance. Court date's going to be tomorrow morning, July 19th at 8:30.
Okay.
All right, step to your right to the T. Next.
Red X.
State your name.
Devin, Tool.
Ms. Toole, you're fully court charged with failing to appear for an uttering forged instrument charge. You understand that, ma'am?
All right, this is the last one. This is the last one I have. So we have about a minute left. You guys are all awesome. Thank you so much for the membership milestones, the gifted memberships, the super chats. You guys are awesome. We are rating American courts, which I think you guys know because I think there was about 10 people that said a name. 9 of you said American courts, and then Jay Hart said, let's go check out a wilderness video, which I would love to do, but 9 people said American courts. So Jay Hart, get with me. We'll raid the wilderness channel because I love that stuff. So we'll do that. But yeah, probably shouldn't start it with saying who do you guys want to raid and then go against what everyone says. So we're going to American courts. I don't know who this is. I've never met him, but you guys all wanted to go there, so I got the link, and we're going there. You guys are awesome. Have a great night. I've got a good good video to start off the morning for you guys tomorrow. Look out for it. Until next time. Bye.
Yes, sir.
Judge Stevenson requests the honor of your presence. We're going to hold you without bond. Your court date's August the 24th at 9 o'clock. Good luck, ma'am.
Step to your right behind her.
You're not live, man. You're not live. I can't rate a premiere. It doesn't work that way. Can't rate a video. I have to rate a live. Lone Wolf. I know, sometimes you just got, I just got to pet you on the head and say everything's going to be okay. In all fairness, he says this to me more than I say it to him. All right, let's finish this up. Lone Wolf, you're great, man. Let's go.
Next. Red X, ma'am. State your name.
Ms. James, you're fully court charged tampering evidence. You understand that charge?
You understand what you're charged with?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, ma'am?
Yes, sir.
Based on your application, you do qualify, and I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
No.
Deputy, criminal history?
No history.
What brings you over from New Orleans?
Just was been under a lot of stress, and someone I was dating offered to take me, somewhere I had never seen, and I accepted.
Bond set at 5,000. Court date's August the 29th at 9 o'clock. Good luck, ma'am.
Step to your right. Next. State your name.
Right.
They just keep coming. I cut it off right at the end of somebody, and every time the defendant walks up, like, this is the last one, and they just keep coming. I have no idea what's going on. But the video says it's 12 seconds till the end, and my outro is 10 seconds. Okay, so that's more than 12 seconds. I can't see it because it's cut off. All right, I'm out for real. You guys have a great night. Let's go hang out with American Court. Lone Wolf, you're awesome. You're awesome, Lone Wolf. Don't let anyone tell you you're not. Otherwise, you're going to eat our throats. So let's go.
Mr. Wright, you're fully court on violation of probation for child neglect charge in front of Judge Young. Do you understand the charge?
Yes.
Judge Gay. It throws me off every time. I've known Shauna since before. All right. Based on your application, you do qualify for the service of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Judge Gay has ordered you held without bond. Your court date is August the 7th at 9 o'clock. Good luck, ma'am.
All right, step to your right. Next.